Hello and welcome to Law and Life. I am Shashank Mishra as a host, present here with renowned senior advocate of Supreme Court of India, Subodh Markandeji. In this channel, Sir explains on various legal issues which are happening around India and also elaborates on different topics of law. Similarly, in today's topic, he will discuss on recent judgments Hajj Group organization not exempt from GST. On this, my first query is who are Hajj group organizers? Why are they not exempt from payment of service tax under the Goods and Service Tax Act for making Hajjis to Mecca and other sites?
Oh, that is because recently on 26 July 2022, the Supreme Court dismissed writ petition number 755 of 2020 and a whole big batch. It's called All India Hajj Umrah Tour Organizers Association versus Union of India. It's a judgment by three-judge bench consisting of Justices A.M. Khanvilkar, Abhay S. Oka, and C.T. Ravikumar.
So, can you tell us kindly more about this case?
So, Hajj is a 5-day pilgrimage to Mecca and adjoining sites in Saudi Arabia. Every year, an agreement is entered into between India and Saudi Arabia to enable 80,000 Hajis who go to Mecca and those adjoining sites to undertake Hajj. 30% of this number is allotted to Hajj group organizers, that is HGOs shortly called, who are private tour operators working on profit. The rest of the number, that is 70%, are assigned to the Hajj committee. That's a statutory body functioning on no profit basis. Petitioners are private NGOs working for profit. They render following service to facilitate the Hajis to perform the pilgrimage. That is, purchasing flight tickets, arranging and making payments for accommodation, food and transport, and arranging foreign exchange, that is Saudi riyals. No religious ceremony or ritual are conducted by the NGOs.
So, what was the litigation about?
The petitioners made a representation to the Government of India claiming exemption from payment of service tax and parity of treatment with Hajj committee. That representation was rejected by the Government of India, holding that petitioners were not entitled to exemption from payment of services, service tax under what is called, mega exemption notification issued under Goods and Services Act, Goods and Services Act. And parity with Hajj committee cannot be given as Hajj committee was a statutory body on no profit basis. The petitioners then filed a big batch of writ petitions, I think 40, 50 in number, under Article 32 of the Constitution, uh, directly in the Supreme Court, raising the very same contentions. The Supreme Court issued notice to the Union of India and heard the matter at considerable length. After appraising the facts, the constitutional provisions, the goods and services tax, and the case law bearing on the subject, dismissed the petitions, holding number one, mega exemption notification grants exemption from payment of service tax only on the religious services, that is relating to conduct of religious ceremonies and rituals. The petitioners are rendering the service of facilitating the performance of Hajj. They are not performing any religious ceremonies. Hence, the mega exemption notification issued under the Goods and Services Act does not apply. And secondly, there is no violation of Article 14 because Hajj Committee is a statutory body. So that's the first distinction. And it works on no profit basis. While the petitioners, that is NGOs, were private tour operators working for profit. So to sum up, two principles have been reiterated by the Supreme Court, namely that the exemption of, from the goods and services tax will apply only if some religious ritual or ceremony is performed by that body, that is in the present case, the NGOs. And secondly, Article 14 does not apply because the Hajj Committee, which is a statutory body working on no profit basis. So that's the classification which is valid. And secondly, the NGOs, work for profit, whereas the Hajj the Hajj committee operates on no profit basis. That is to say, the Hajj committee, being a statutory body, works on no profit basis, while the NGOs, who were private tour operators, work for profit. These are the two principles which have been laid down. That is why NGOs are not entitled to exemption from payment of service tax under the Goods and Tax Services Act, that is GST.
Yes, sir, this will cover all the facts of the cases, and with that, we will conclude the session for the day, sir. Thank you, sir, for joining.
Thank you.